Hi, I'm Ian Hull,
And I'm Rebecca Rauws.
and welcome to Hull and Estates. This is episode number 545, and today we're going to be discussing an important litigation concept that comes up from time to time in estates, and a recent Court of Appeal decision that specifically deals with it, and that is the concept of summary judgment. So when you get embroiled in a lawsuit relating to estates and relating to any matters in litigation, you have available to us in our rules, and across the provinces have the same rules, the opportunity to cut the case down a little bit by getting a summary judgment motion. And that is where the court will, in a summary and shorter fashion, make an adjudication and a decision on your case. Now, the usefulness of summary judgment motions in estates has been debated for a long, long time. Probably 20 years ago, more than 20 years ago, my dad wrote an article in the Estates and Trust Reports on summary judgment in estates, and at that time opined, in some respects, that the concept of shortening or cutting down an estate case through summary judgment may not be the most effective tool for the courts to use. And that debate has swirled around, and we've gone back and forth on whether summary judgment prevails or doesn't prevail, and then to what extent it prevails. So today, Rebecca, let's discuss a recent Court of Appeal decision and see where the pendulum has flowed in regard to whether or not the courts will look to and apply this summary, cursory, shortened trial type arrangement with summary judgment.
Right. So the case that we're going to talk about today is a decision of the Court of Appeal. The name is Aird Berlis LLP and Oravital Inc. And that's a decision from February 2018. The facts are not really that important to the discussion of summary judgment, but basically there was a law firm and its clients, a couple of corporations. The law firm brought a claim against the corporations for unpaid fees, and the corporation brought a counterclaim against the law firm for solicitor's negligence.
So just to pause on that point, I do find in my practice that can be an almost 80% of the time tool. When you sue clients for fees, they tend to then turn around and say, not only we're not going to pay you, but we're going to tell you you did a lousy job and you screwed up. So that's sort of a fair warning.
Yeah. They were asking for it.
That's right.
So the details of what the law firm was hired for are not really super important. But basically, they got to a point where the law firm brought a motion for summary judgment, and both sides, the law firm and the corporations, everyone agreed that it could be dealt with on a summary judgment basis. So
that's really interesting, because rarely do you get in a situation where you are in a summary judgment fight where one side says, well, this is for sure a summary judgment motion and we should be able to do it in a cursory way, and the other side agrees. And in this case, of course, when you're fighting over invoices, the specifics of the legal issues are really more important than the facts, because the facts are going to be, well, here's the bill and here's the work and services.
Yeah, and I think it's interesting that the fact that there was the counterclaim, I think, really must have affected the Court of Appeals finding in this anyway. So on the motion.
Sorry, so let's just jump to I always hate reading cases not knowing what the result is and then being told about the case after. So the result was at summary judgment at first level.
At the first level, the court granted summary judgment in favor of the law firm, saying that they should be paid, and dismissed the counterclaim by the corporations.
And then at the Court of Appeal, what was held?
The Court of Appeal set aside that judgment in favor of the law firm and the dismissal of the counterclaim.
So interesting. Flipped it around on us. And so on what basis did the Court of Appeal say no summary judgment here?
The Court of Appeal actually found that on the record before the motion judge, it wasn't available to the motion judge to make the findings that they did. Most of the findings were relating to the counterclaim and what the law firm did.
So the counterclaim being the negligence claim?
Yes.
Yes. So there wasn't really much of a fuss over the payment of fees, the amount, and who should pay how much. It was more about the fact that the company, the client, said, well, actually, not only we don't owe you money, but you negligently acted on our behalf. And at first instance, the trial judge said, no, you know what, I can still make a decision on that. And the Court of Appeal said, no, for finding a negligence, like this,
Mhm.
we're going to send you back and try again.
Right, and there was too many contentious issues, and the Court of Appeal thought that a trial was necessary in this case. I think it's interesting that they had agreed that it could be dealt with by summary judgment, but the Court of Appeal said that the parties were mistaken in agreeing to this.
So it's a really interesting intervention, as you say, by the Court of Appeal when they turn around and say, nice try, we're not going to let you bring forward a matter for adjudication in a summary way when we think it should have been more fulsomely considered with facts at a trial.
Right.
And so you can see where in a will challenge or in a wills and estates matters, I've always struggled with the use of summary judgment, and maybe personally think it's this case is actually sending the right message because it is factually based. When you are testing the question of testamentary capacity, you are making a legal determination and you're making a factual determination. And those things are tied together because you need to know the test and you need to know how that test is applied to the facts. So you can see how in almost no scenario a will challenge is properly brought in a summary way.
Yeah.
But undue influence has been found in the past to be dealt with in a summary fashion. And the courts have, and the Court of Appeal has even encouraged that in certain instances. So it's still a bit of a mixed message out there in terms of how much we use summary judgment and what flexibility, even when the parties create the flexibility, what flexibility the court is going to let us.
Right, exactly. There's a part of the rule that deals with summary judgment specifically says that the court has to feel it's appropriate, even if the parties agree. So I think that's what came into play here.
Wow. So a good message for all of us to, even when we counsel are thinking of behaving themselves reasonably and sensibly, you can get to a level of the Court of Appeal where they will second guess your own procedural decisions and your own procedural summary fashion in which you're going to proceed. Well, that concludes our podcast today. Until next time, we thank you very much for listening. And I'm Ian Hull.
I'm Rebecca Rauws.
And if you have any questions, please do not hesitate to email us at webmaster@hullandhull.com or leave a comment on our blog. Thanks very much for joining us.